Today our topic is Wayleaves, easements and related powers that are held by the utility companies. And we're going to be taking a look at some of the legal and practical aspects of this area of practice. We're going to be looking at where the legal powers come from, how that underlines the procedural and valuation aspects which must be brought to bear when dealing with these types of power. We'll be mentioning compensation for the initial rights that are taken, as well as the compensation which is available when those rights are subsequently exercised. We'll also pick up a few points about removal and resiting of some of the installations, and of course, what happens when things go wrong. Old Wayleaves often raise various issues, particularly where the original grantor of them is no longer in ownership or occupation. In fact, one of the problems that quite often arises is the problem of tracking down the origin of some of these Wayleaves. A broad principle is that compensation is available for all the sorts of powers that we're talking about, and compensation should cover all the loss that flows from the grant, provided it's not too remote. Generally, most of the powers that we're going to be talking about are the responsibility of the upper tribunal lands chamber when it comes to disputes over compensation and other aspects of the right. The Pipelines Act of 1962 allows for compulsory purchase of land, and it also allows for something which are called compulsory rights orders, a wayleave by any other name. Electricity wayleaves are covered by a plethora of arrangements, and these in practice can be some of the most difficult, particularly for buried cables, which a new owner may not even know are there.